This is Laws 11057, Introduction to Law. It's a continuation of our discussion in relation to the Real Estate Institute of Queensland contract, a contract which is co-prepared with the Queensland Law Society. And the reason I'm keen to introduce this to you is that it's regarded, generally speaking, as a relatively basic, commonplace aspect of legal practice to be involved in conveyancing. What you've probably gleaned from my comments so far is that in my view it's anything but. I believe it's a very difficult area of practice and it's underrated. But given that it's something that you may be exposed to in your first week in practice in a law firm, I believe it's important that we give you a taste of what's to come. Last week we got as far as the end of the front page of the reference schedule to the contract, just over the page, and I propose to continue with my discussions. I think I may have mentioned that in a tenancy situation, we do insert the name of any existing tenants and make reference to any existing lease arrangements. The contract is made subject to the continuation of those lease arrangements. If there is a lease in place and the contract makes no reference to it, then from the seller's perspective, the seller may be in breach of contract if they're unable to provide to the buyer what we call vacant possession. Now, I'm assuming that you can see the REOQ contract and you can see my cursor moving around. Please let me know if that's not the case. All right, well, let's continue. The purchase price is described by reference to the price itself, less a deposit, and the deposit can be in two parts. An initial deposit payable when the buyer signs and a further balance to the deposit at a later time. Generally speaking, a deposit is an amount of money which is liable to be forfeited, to be lost, if the buyer does not complete the contract as required. There is one very common exception to that in practice, and that is where the contract is made subject to a condition, usually finance, and that condition is not satisfied, then the general rule that the deposit is to be forfeited does not apply, because in those circumstances, even though the buyer didn't complete the contract, the buyer did so in circumstances where he or she or they were not in breach. So if the contract is subject to finance and the condition or any other condition, and the condition fails, then in those circumstances the buyer would be entitled to a return of deposit. It's only if the contract is not completed in circumstances where the buyer is in default that the deposit is liable to be forfeited. The deposit is, generally speaking, 10%, but in practice it's rarely 10%. So the 10% is more a theoretical figure, but in practice the figure is more like somewhere between 3 and 5% of the purchase price. Just enough, quite often, to cover the agent's commission. Finance, I've talked about the need for finance, and last week we talked about the need to look at the fine print. In this instance, have a look at the contract on the right-hand side, where it does say that if the contract is intended to be subject to finance, then each of these lines, the finance amount, the financier and the finance date, should be inserted. If not, then the contract is not subject to finance and the finance clause does not apply. So if you're acting for a buyer, it's vitally important to determine whether the buyer is relying upon finance in order to complete the acquisition and insert appropriate details. Now, when it comes to the details, firstly the finance amount, there are two schools of thought here. The first is that some people believe it's appropriate to put in an amount of money. Others believe that it's an appropriate thing to put in a description being sufficient to complete the purchase. My personal view is that it's better practice to put in a dollar figure rather than describe it as simply an amount that's required by the buyer. Secondly, financier. in my view, when you're acting for a buyer, it's better practice to be specific. And if, for example, your intending purchaser wishes to finance the transaction through a loan through, say, Westpac, then insert Westpac. And the finance date would normally be about 14 days from the date of contract. The reason, in my view, you should be quite specific when talking about the finance details when acting for a buyer is that if the buyer is unable to obtain the amount of money which is being sought from the financier in question, then the buyer has the opportunity to terminate the contract, call it off, and recover the deposit. If you leave anything in more general terms, then arguably the buyer has to do more work in order to justify terminating the contract for failure to obtain finance. So if, for example, we put in finance amount, sufficient to satisfy or to purchase, that is then subject to further inquiry. If we put in financier, any financial institution, then we leave the buyer in the difficult situation of having to shop around. And it may be, for example, that Westpac says no, but a secondary lender is prepared to finance at a much higher rate, and your client, the buyer, may not be prepared to borrow at that rate. So you've done your buyer client a disservice by not being specific in terms of nominating the financier. I hope that even though I've gone through that very quickly, that makes some sense. Building and inspection. Now just note over on the right hand side that if the inspection is not completed, or if the inspection date is not completed, the contract is not subject to an inspection report and the clause does not apply. So again, if your client, who is a buyer, is intending to undertake a building or pest inspection, make sure that you insert an inspection date, otherwise the contract is deemed to be unconditional in relation to that aspect of it. I'm going to move fairly quickly over things to do with pool safety and electrical switches and the Neighbourhood Dispute Resolution Act. They're fairly straightforward matters for consideration. Special conditions, these can be very wide and varied. A very common special condition is that the contract is subject to the sale or completion of a sale of the purchaser's own property. But there are many other special conditions that might be inserted. Now I'm just going to work my way down to some of the more important conditions to bring to your attention. Now the first is GST. We talked about that last week, and just be aware that there is no GST liability imposed on the buyer in addition to the purchase price in these circumstances. We talked about the entitlement to deposit and interest previously, and the party entitled to receive the deposit, if the contract settles, is the seller, or if the contract is terminated without default by the buyer. But if the contract is terminated owing to the buyer's default, then the seller. And that's really stating what we talked about just a moment ago.
I have a question.
Yes, Carla.
In what cases is the buyer not liable to pay the deposit? I know that if he's not in breach of the contract, but what are some of the conditions where he's not in breach of the contract and he's not required to forfeit the deposit?
Essentially, if there is a condition in the contract which is not satisfied, then provided the buyer didn't cause the condition to fail, the buyer would be entitled to return of deposit. The most common ones are that the contract is subject to the buyer obtaining finance, that the contract is subject to the buyer obtaining a satisfactory building and pest report, that the contract is subject to the buyer settling on the sale of their own property, or something along those lines.
Okay, thank you.
Thank you, Carla.
Can I ask a question about what satisfactory would mean in the building and pest situation?
Yes, thank you, Rachel. I think the clause is clause 4, and I think we should look at that now. So the contract
Okay.
is conditional upon the buyer obtaining a written building report. The buyer must take reasonable steps to obtain the report. The buyer must give notice to the seller that a satisfactory report has not been obtained, and the buyer must act reasonably. If the buyer terminates the contract and the seller asks for a copy of the building report, the buyer must give a copy, and the seller may terminate the contract if notice is not given. You'll see in there that there is no definition of what is satisfactory, and that really comes down to an argument between the buyer and the seller. I'm sorry that's not a direct answer to your question, but it's a question of degree. And essentially, it really comes. It's almost a subjective test, but it's not quite. The buyer must act reasonably before being in a position to terminate. But no, there's no hard and fast rules there in that contract. Yes, sorry, Rachel.
No, it's me actually again.
Oh, sorry, Carla. Yes.
Where can we find a copy of this application?
Do you mean the contract?
Yes, the contract.
This one that we're looking at here?
Yes, if it can be uploaded to Moodle so we can look at it and read
Yes.
it, get more familiar with it.
Exactly. I want to do that. I need to be satisfied about copyright entitlements, but I do propose to do that, yes. Thank you, Carla. Now, I know that's a brief answer to your question, Rachel, but do you understand that it's a question of degree and potentially open to argument?
Argument means what? Time and expense?
Yes, both of those things. And of course, what may be a satisfactory building report to one buyer may, of course, be an unsatisfactory report to another buyer.
Yeah.
Now, I want to mention something about Clause 6, which is time of the essence of the contract. What that means is this. It doesn't come down to hours or minutes, but it does come down to days. So if the contract requires settlement on, for example, the 30th of June, then if the buyer is not able to settle on that day, then in general terms, given that time is of the essence of the contract, it means that on the 1st of July, the seller is entitled to declare the contract at an end and declare that the buyer is in default of that contract. And that has a number of ramifications. The usual one is that the buyer forfeits the deposit which has been paid. It's lost to the seller, and the seller is then free to sell the property to someone else. There are other ramifications, but I won't go into those now for these purposes, but that is one of them. There are a number of warranties which are contained in 7.4, and the contract is subject to the buyer being satisfied that if a survey report is done, that there are no errors in the boundaries or encroachments. If there is a material error or encroachment, then in those circumstances the buyer may be in a position to terminate the contract. But if it's immaterial, then there may be a question about compensating through money alone. Now, I do want to bring your attention to this clause 7.6. 7.6 says that any valid notice or order by a competent authority, let's say a council, or a court requiring work to be done or money to be spent, must be fully complied with if it's issued before the contract by the seller, or if it's issued after the contract date by the buyer. If any work that is the seller's responsibility is not done, the buyer is entitled to claim a reasonable cost for rectification, and so on. But really, let's think for a moment of the ramifications of clause 7.6 subclause 1. What it means is that if you purchase a property and you then undertake a council inspection of that property, now this is different to a building inspection, which is referred to in clause 4, which is where you normally have your own building consultant come out and do an inspection. 7.6 is really talking about a council inspection. So as part of the conveyancing, the buyer's solicitor asks the council to go out and do an inspection. The council officer notices something. Let's say that downpipes from the roof haven't been properly catered for, or maybe a garage has been converted into habitable space and the roof is too low for that habitable space, or whatever it is. The council officer comes up with something which is a problem. Given that the council officer is there and becomes aware of the problem, the council officer will need to issue a note, a requisition or a notice for that to be fixed. Now, the interesting thing is that that notice, that requisition, that order, if you like, has come about after the date of contract, because the date of contract is the date when the contract comes into existence. It's not settled because there's normally 30 days between the contract date and the date of settlement when the property transfers. So you can see from that clause that by asking the council to come out and undertake the inspection, the buyer's solicitors have inadvertently perhaps exposed their client to the existence of having to rectify an order which has now been issued, because the clause here says that if the valid notice or order is issued on or after the contract date, then the buyer must rectify that work. Now that's something that I think you need to bring to your client's attention if you're acting for the buyer, and you may need to consider putting in some special condition to effectively reverse the effect of that clause. Any questions about that?
Sounds like it might be a good idea perhaps to get that done before you sign the contract.
Look, I think that's a very good idea. That's a sensible idea. It costs a bit of money, but that is one way to do it. Sometimes what happens is that people rely on their building inspection, their private inspector, who has no power or interest in issuing notices or rectification requirements, rather than have the council come out and do that work. All right, well, we might move on. Risks. Now, the risk of the property is with the buyer from 5 p.m. on the first business day after the contract date. Let's think about clause 8.1. What does that mean? We've identified that the contract date is the date that the parties are bound by the contract. That's usually, say, 30 days before the settlement date. The property is at the buyer's risk, essentially, as soon as the contract is signed. So, we have a contract signed on day 1. It's due to settle on day 30. On day 28, cyclonic winds come through and the roof is torn from the house. If I read that clause correctly, it says to me that the buyer is still required to pay the full purchase price, even though the buyer is acquiring a property which now has no roof. Does anyone disagree with that interpretation? Does anyone have any suggestions on what you should therefore do?
Is that like insurance, John? Do you have to get insurance for the place you're looking at buying?
Exactly, Jackie. Yes.
But what I wonder, John, does that mean the person selling it still has to pay insurance as well? So the insurance company's got both people paying it?
Generally speaking, as a matter of course, that's what's going to happen. But certainly if you're acting for the buyer, I think you should accept that the buyer is responsible for any risk and therefore should take out insurance. Equally, if you're acting for a seller, it would be, in my view, a brave piece of advice to say, well, you don't need to insure now because it's at the buyer's risk. Because the fact is that the buyer may not have any money, may not eventually settle, and may not take out insurance on the property, even though it's at their risk. So I think it's wise for the seller to maintain insurance as well. That leads to the next problem, that we then have potentially 2 insurance policies catering for the same property, and that can then lead to other complicated legal arrangements. But for the purposes of this course, I think the point to be taken from that is that in that very first session, when you're advising a client who's in the process of buying a property, that you should urge the buyer to take out a reasonable policy of insurance straight away. You okay with that, Jackie?
Yeah, no, that's good. Thanks, John.
All right.
And at the end, if they have this contract subject to finance 5 days before, 5 days before the contract's due to settle, they say, "Oh, look, we can't get the money."
Yes.
And then we're not buying it, so that means that they're out of it then?
That's right. Yes. If they purport to terminate the contract for failure of because a special condition is not satisfied, then generally speaking, that would be a valid termination of the contract, and they would be entitled to return of their deposit. Correct.
What if the cyclone happened the day before, the night before,
Yep.
and then they found out the next morning they couldn't get the finance?
Well,
They're
that's
still
right.
liable.
Exactly. The financier may say, well, no, circumstances have changed. We're not funding on this one. Unfortunately, the buyer is liable because even though the contract was initially subject to finance, typically what we find is that the date due for finance approval to be advised to the seller is about 2 weeks after the contract is signed, about 2 weeks before it settles. So if we have a contract signed on day 1, we have settlement on day 30. If day 14 is the finance day or the finance date, it doesn't mean that's the day that the financier passes over money. It's the day that the buyer says to the seller, yes, we have approval of finance and the contract is now unconditional. And you're right, Jackie, it can happen that between day 14 and day 30, circumstances change where the financier is not prepared to fund, but the buyer is still liable under the contract and will potentially suffer loss of deposit and maybe even more.
Thanks, John.
Thank you. All right. Clause 9 deals with if one party does the wrong thing, what the other party can do. They can either affirm, which means proceed with the contract and do certain things, or terminate the contract. That's what happens most of the time. If a party is in default, the other party will normally terminate the contract rather than say, all right, we still want this contract to go ahead. They'll normally terminate the contract. Usually it's the buyer that might terminate. The buyer may be in default. So if the buyer's in default and the seller terminates, the seller may, amongst other things, forfeit the deposit which was paid by the buyer, and then sue for damages as well.
I'm interested in, for example, here in Queensland, you have issues of flooding.
Yes.
So what if there's a contract and, like Jackie said, like 1 night or 2 nights before the settling of the contract, there's a huge flooding disaster or something? Who would be, does the buyer have the right to cancel the contract or not?
Generally,
That's where it would come in, wouldn't it?
no, generally speaking, no. If the contract by that stage is what we call unconditional, then generally no. And look, another type of example would be that a buyer is retrenched after receiving finance approval, but before settlement, the income is gone. That's generally not regarded as good reason to terminate a contract, and the deposit's forfeited. Can be tough.
So he's forced to buy the property even though it's very damaged?
Yes, potentially, Carla. Yes.
Yeah.
That's where you need to be.
Yeah.
Yeah, you need to be
Because
very
she's-
careful. Yeah, sorry. No, sorry, Carla. I can't see you see.
Yeah, that's why. Let me. It's the thing is because Rachel. I think because the reason why I'm thinking about that is because of Rachel's question about when the financier has the right to reply, and we have to give like two weeks notice and all that. So that's why I was wondering, what if I mean, if I'm the buyer and I tell the seller that, okay, everything's fine, I've got the finance, I'm settling and everything, and like one day before there's a huge flood in Queen, and the council came and did all the inspection, and I made sure that the inspection, the council's inspection is terminated before the settling of the contract, just to be on the safe side. And then after the council left, there's a huge flood, and there's a lot of damages on the property, like really, really substantial damages.
Yes.
So I'm doomed to pay for all these damages, right?
Insurance.
Yes, unfortunately. Yeah, sorry, Jackie.
Okay.
Sorry, I was just saying, if you've got the insurance cover and it covers for that, well then that should pay. The insurance should pay.
Well,
but
that's
the insurance
right.
doesn't start until the day of the settlement. So I'm not covered by the insurance yet.
No, but Jackie's right in that what I suggested before is that the buyer should take out a policy of insurance, and because it's at their risk, I believe the insurance company would be liable, having accepted that policy of insurance, even though it hasn't settled.
So that was my next question. So if we want to take out an insurance on the property that we want to buy, we have to make sure that the date of the start of the insurance would be before the settlement?
Exactly, straight away.
Okay.
So
right.
what you do is you recommend to your purchaser clients that as soon as they sign the contract, they go and organise their insurance effective immediately.
Okay.
Right. But very good questions. All right.
Sorry for interrupting all the time.
Oh, not at all. No, please do. Please do. All right. Any questions then? All right. What I propose to do now is just provide you with some notes in relation to contract law by way of quick introduction. Is that okay?
Yeah.
Now, can you see on my screen some notes about contract law?
Yes.
Great. All right. Let's go through this introduction to contract law. The formation of a contract. Contract requires an agreement, consideration, and intention to enter legal relations. And to have an agreement, we need an offer, an acceptance, and a communication of the acceptance to the person who made the offer. So therefore, one can take from that, given that an agreement is in three parts, that what we really have is 5 things that are needed for a contract in general terms to become effective. We need an offer, we need an acceptance, we need a communication of the acceptance to the person who made the offer, we need consideration, and we need an intention to enter into legal relations. Everyone see that? Now, what do we mean by offer, acceptance, and communication? So these 3 things here. An offer may be distinguished or must be distinguished from an invitation to treat. An invitation to treat is a request to others to make offers to engage in negotiations with a contract in mind. There are some consumer protection laws that come in here and provide protection, but let me give an example of an offer versus an invitation to treat. If you go into your supermarket and you see advertised for sale a dishwashing liquid for $10, it might appear that that's an offer to sell that to you for $10, but the actual, from a legal perspective, that is really an invitation to treat. When you take that dishwashing liquid to the counter and you then take it and present it for purchase, you are then making an offer for purchasing that, and the price that you're offering is $10. Now, theoretically, that then is subject to an acceptance by the representative of the store, and obviously you're communicated with that acceptance straight away. But an invitation to treat is really an invitation to have someone come in and make an offer to purchase that property. I'll give you one example.
There's a famous case about that, about this. No, about this, I think, if I'm not mistaken, and
Yes.
it happened in a pharmacy.
Yes,
I think.
The Boots one, yeah.
exactly. Carlisle, Boots Pharmaceutical case. Exactly.
Yes,
Yes.
yes.
Very good. Situation that occurred. My wife actually was in a jeweller's. She saw a range of watches. They were all the same price except for one in the middle. She then said, "I'll have that one." And as the person who was attending to the matter went to ring it up, it came up with the price that it should have been, rather than the price that it was actually stated on the screen. On the display. And my wife argued that they had made an offer, but in fact she was wrong. It was an invitation to treat. So simply being advertised at a certain price is not technically an offer. It's an invitation to treat. As I said, consumer protection laws do have some effect on that, and that's a terrible colour.
It can get confusing, John, can't it, trying to get your head around it, because without knowing all this, without knowing this, anybody would think, well, I'm going into a shop, they're offering to sell me that, like it's offering for sale, but it's actually not. So
that's right.
Yeah, it can get confusing.
It can be, absolutely. All right. Now, acceptance is generally included in contract only where it's communicated. Let me take another example. We have a real estate transaction. The buyer signs an offer to purchase a property during the afternoon. The agent physically drives to the seller's property, and in the early evening, the seller signs the contract. We have, therefore, a document which is called contract, and both signatures are on this document. Let's assume that 10 minutes after the seller has signed the contract, and while the agent is having a cup of tea with the sellers by way of celebration that the contract is now signed, the buyers phone the agent on his or her mobile phone and say, look, we've had to think about this. I'm sorry, we withdraw the offer. We don't want to go ahead with it. The agent may well respond by saying, I'm sorry, it's too late, the contract's signed, it's a done deal. But given that as an element of a contract or an agreement in first instance, there must be a communication of the acceptance to the person who made the offer. It follows that, as I've stated here, it's free for the person who made the offer to withdraw the offer until such time as acceptance of it has been communicated back to the person. So, if you're ever advising a real estate agent on what they should do, once the contract is signed, they should immediately get that contract back to the buyers, notify the buyers that the deal is done. In other words, close that loop. We talked about an offer, an acceptance, and a communication of the acceptance back to the person who made an offer. Okay? I know that's a bit tricky, but any questions about that? All right. In addition to those three things that might constitute the agreement, we have these concepts of consideration and intention to create legal relations. Now, what does that mean? Consideration is essentially the provision of a mutual benefit in most instances. Let's take a real estate transaction. The buyer receives consideration because the buyer obtains a property. The seller obtains consideration because the seller receives money. So both parties receive a mutual benefit, and that mutual benefit is sufficient to constitute consideration as we've defined it. Sometimes consideration can be established through detriment to one party. That might be having to incur some expenditure or work or forbearance. But generally speaking, think of consideration as being a mutual benefit. property in exchange for cash. I've said here that consideration is not necessary if the agreement which is entered into is a deed. Now that's a technical term, and it's simply another type of arrangement. Now, I don't want to go into too much detail on this because it's a bit technical, but in a way it's simple. There are two ways to document an agreement. One is a contract, and the other is in the form of a deed. And if it's a deed, it's the normal giveaway for a deed are the words signed, sealed and delivered. And a deed used to be, in the old days, something where the sealing was the affixing of a seal, a family seal or a company seal. And it used to be, when I started in practicing law, we used to affix these seals, which are really stamps, with wax. We physically would have a wax seal, and that's a deed, as opposed to a contract. Now, they kind of look the same, but there's a subtle difference, and you don't need to worry about it too much now, but just be aware that consideration is not necessary if we're talking about a deed. So just keep that in the back of your mind for later reference. And intention to enter into legal relations, the parties have to be serious that they want this to be an agreement which is legally binding. Now, there is a presumption that relatives don't intend their agreements to be in the form of a contract. So let's say if a brother and sister arguing over the dinner table and the brother says, all right, I'll take the rubbish out if you do the washing up. The brother then takes out the rubbish and the sister refuses to wash up. The brother's not going to get anywhere in terms of arguing there's been a breach of contract, because the law says, look, your relatives, we presume that you don't intend this agreement to be in the form of a legally binding contract. It is a rebuttable, or no, I put refundable there, that should be rebuttable presumption, but the presumption is that when it's family members, they don't intend their agreement to be a contract.
Is that based on common law?
Good question. Yes, it would be. I'm not aware of any statute that says that, Rachel. Excellent. Now, contracts require a written agreement. From what I've said so far, most contracts don't require anything in writing, and most contracts would be oral contracts, but there are some which must be in writing. Real estate contracts and guarantees must be in writing. And in that regard, you can look at Section 59 of the Property Law Act, which says that a disposition of land it must be in writing. I know this is quick, but thank you for bearing with me. Remedies. If there's a default by one party, the other can seek a remedy, and the most common is damages, which is an award of money. Alternatively, they can seek an equitable remedy. Now, remember we've talked about law versus equity and legal remedies versus equitable remedies. Equitable remedies are intended to create a situation which is fair, and the two most common equitable remedies when talking about real estate are specific performance and injunctions. Specific performance is where you get an order of the court essentially forcing the other party to go ahead with the deal, that the deal must be specifically performed. You've got to go ahead. So if, for example, a seller of real estate for no good reason says, no, I'm not selling this property, I've had a change of heart, I really want this to go in my will to my son, the buyer, who's disappointed, can go to the court and say, essentially, court, can you please force this person to sell this property to me? I'll pay the money, but I want this land, or I want this property at the price we agreed. The court can order that the seller specifically perform the contract and force the sale. An injunction's a different thing. An injunction is where you seek an order of the court to stop someone from doing something. And you've probably heard of injunctions in general readings. Limitation period, if you're going to sue for a breach of a simple contract, generally it's got to be within 6 years. And then we'll go from there. Now, I think we've got just a little more time. Any questions on what I've done on property law or contract law? I won't do family law. Okay, really quickly.
I have a question concerning the relatives. I didn't quite get that idea. Why is it, I mean, if two brothers have a contract between each other,
yep,
according to common law, the courts should not take that into consideration? Is that the case, or?
Yep. There may be an argument about whether the parties, brothers in this instance, intended that by signing the agreement or entering into the agreement, they intended it to be legally binding.
John, it's different if it's commercial though, isn't it? Like if two brothers have a commercial, that's different from domestic agreement.
That's different.
Yeah.
And in that situation, if it was a commercial agreement, substantial amounts of money, they both had separate lawyers, it would be very easy to overcome that presumption, and I'm sure that it wouldn't even be argued. So it's only a presumption, it's not an absolute rule, Carla, if that answers your question.
Okay. So it depends on what area of the law we're talking about, or we should consider it as a presumption in everything.
Presumption in contract law at this stage. I wouldn't go beyond contract law. Okay. All right. Well, look, I'm just going to finish with 5 minutes on constitutional law. Constitutional law, you'll see that the main legislation, the Commonwealth Constitution, of course, itself, the Statute of Westminster, the Australia Acts and the Constitution Acts of several states. If you're going to consider the Constitution at all, I'd suggest that you start by considering Section 51 of the Constitution, and that provides a list of powers which are given or conferred upon the Commonwealth. So if the Commonwealth makes a law, it must do so based on the power which is conferred upon it by the Constitution, and that's in Section 51. But if there is a conflict between state law and Commonwealth law, then Section 109 says that if there's an inconsistency, we go with the Commonwealth law. So take an example, it may well be that the states have power to make orders or laws in relation to same-sex marriages. Let's say if there's a dispute or an inconsistency between laws, then the Commonwealth law will prevail in those circumstances. Now, we talked early on in the course about the Mabo decision, and you'll see that that has constitutional ramifications. And I'll read: the proposition that Australia had been a settled colony and that legal title to all land in Australia became vested in the Crown upon settlement was repudiated by the High Court in Mabo. And just to round off, there's some of the more notable powers in Section 51 of the Constitution. Powers to make laws in relation to trade and commerce, taxation, external affairs, corporations, defence and matrimonial. Now, that's a very brief introduction to into constitutional law. It's really a very interesting subject once you get into it. Well, that's probably getting close to where we would stop for tonight. Are there any questions?
The High Court has no business settling cases between the Commonwealth and the states, because I remember there's a case where there was a dispute over whose jurisdiction, if the state has jurisdiction to trial the case, or it's a Commonwealth law, Commonwealth jurisdiction. And so I think what my question is, if there's a dispute between the Commonwealth and the state law, we should automatically presume that the Commonwealth law will prevail. There is not any case that it might go to the High Court for it to be settled?
Yes, I agree with your first comment. Pursuant to Section 109 of the Constitution, in the event of an inconsistency between Commonwealth and state law, the Commonwealth law applies. But I'm not sure I agree with your proposition that the High Court would not hear a dispute between the Commonwealth and the state. I think they would. I'm not sure I can think of any instances where there has been litigation between the Commonwealth and the state in reality, but I suspect that the High Court would hear the matter if there was. I hope that answers your question, Keller.
I have a question.
Yes, Rachel.
I've read in the textbook, it talked about heads of power. Can you explain what that means?
Heads of power? Are you talking constitutional?
I think so.
Yeah. Look, I suspect, and I may be mistaken, but I think they're probably talking about these powers in Section 51.
Okay.
And I've just listed 6 there, but there's many more than that.
How does the environment fit into that area? Because I didn't. Does that just come under external affairs according to treaties, or is there like there's a federal environment department, but there doesn't seem to be. It doesn't seem to be specifically mentioned in the Constitution.
No, and I must confess I can't recall whether the word environment is specifically in Section 51. Sorry, Rachel.
That's all right. If you're looking at doing this subject on constitutional law pretty soon, it is a Year 2 subject. Would it be something that we'd be able to take on at this stage, say next term? Or? Yeah?
Absolutely.
Okay.
I think constitutional law is a good one to do early on.
Oh, great. Thank you.
Okay. All right. Any further questions?
John, I just have one question. I'm sorry, it's back on the real estate form. I just wanted to wait to back on the real estate form contract where you said about putting in the financier.
Yes.
So, and you said it's better to put in, like you put the purchase price, then you put the finance amount. And I have seen them where they say sufficient to cover purchase, but you said it's better to just put the amount. So that finance amount is only, just say someone was borrowing extra to get a car as well as a house. It's only the amount for the house that they're buying that would go here. Is that right? That's all?
Not necessarily. If it's intended to be one loan to cater for 2, you can insert that amount. Strictly, it should only be for the real estate, but it might be that in order to acquire this real estate, there needs to be more borrowed than might otherwise be the case to consolidate some loans, some credit card loans or maybe some other debts, and the financier won't agree to finance the amount unless those other debts are cleared. So people often use the purchase of a home as an opportunity to consolidate some smaller debts as well. So the point though is that if, let's say the purchase is for $400,000, let's assume that in order to purchase this property and clear the other debts that need to be cleaned up, the buyer needs $300,000, then I think you should put in the figure $300,000. What that means is that if the financier says, look, we're prepared to give you funding, but the most we will go is giving you $270,000, by having inserted $300,000 as the amount that the buyer is required to obtain to proceed, it entitles the buyer to terminate the contract, because even though they were approved for finance to $270,000, they weren't approved for finance to $300,000, and that was the condition.
Okay.
Now,
and with this, sorry.
They can always waive that. They can say, look, that's okay. We're still happy to proceed even though we didn't get the amount that was inserted in the contract. it just gives them that opportunity to terminate if that's what they want to do.
Okay, and that finance date, is that what you said, like the 2 weeks after they start the contract? Is that when they should have the approval? Is that what that finance date is?
Exactly. It's
Okay.
it's not the day that the money changes hands. It's the date that the buyers can say, yes, we have now received an approval from a financier that funds are available and will be made available for settlement.
Okay, last question. When you said before, John, with the financier, like I said to you, I've seen it where they've put buyer's choice, whatever they want. But did you say before that it's okay to do that, or it's better to put a specific?
From my perspective, in acting for a buyer, I would be specific. Because if you put buyer's choice, the concern that I've got is that the buyer may be approved from one organisation and not the other. And you've got to bear in mind that the buyers are under an obligation to show good faith in this transaction. And if they're approved from one and not the other, then they may be forced into a situation of having to proceed in circumstances where the interest rate is higher than they can afford, for example. So,
and how would the seller find that out? Like, is that something that the buyer has to disclose? If it had buyer's choice there?
No, I hear what you say. Not necessarily, but the buyer can sometimes be caught out. Sometimes people use the finance clause as almost like an option clause to say, well, I'll go ahead if I feel like it. And what they then do is that sometimes they fall into the mistake of buying a different property. So if the seller is not happy that they pulled out of their particular contract, they know that they've bought something else, which buyers often do. They might be tempted to issue proceedings for damages on the basis that the buyer did not proceed in good faith.
Is that likely to be successful? Have you heard of those cases and they are successful for that reason?
Oh, it's a tough ask for the buyer to take on litigation, and many buyers shy away from litigation because of the cost and potential risk. So no, I wouldn't say it's common. No.
That's possible. Okay. Thanks, John. Thanks for that.
Thank you, Jackie. All right. Any questions, Carla, Rachel? Okay.
Just one, the information that you went through tonight on contracts, will that be on Moodle?
I haven't yet put anything up on Moodle from this contract. I hope that I can get the approval to put in the contract on Moodle, and I'll see if I can do that shortly.
I mean also the information that you were going through with us that you had done.
Oh, those notes. Oh, I can put those on Moodle. Yeah, that's fine.
Okay. Thank you.
The inspection, the pest inspection, it's for the buyer to pay for it, or for the seller?
For the buyer to pay for it, yes. That one there. That's it. The buyer pays for that. All right. Okay, well, we might stop at this stage, and I thank you very much for your attendance again, and we'll speak again soon. So I'll stop the recording now.
Thanks, John.
Thank you very much. Okay, bye.